For our project, we chose to cover the topic of an important part of historical journalism. This is libel and slander versus the truth, the Zenger trial. So what is libel? The definition of libel is a published false statement in writing that can be damaging to a person's reputation. An example of libel is as simple as a quick false sentence. The sentence, "Jane Smith was caught last night robbing a home," is short but can be very damaging to a person's rep. So we know libel is the act of writing false statements. However, slander is the action or crime of making a false spoken statement that can be damaging to a reputation. We can see that the statement, "Jimmy Carter committed tax fraud." This is a big deal, and simply saying the statement can lead to a frenzy of backlash. Moving on to the truth. We know that the truth is an absolute defense to libel claims because one of the elements that must be proven in a defamation suit is the falsity of the statement. The Zenger trial was a very important case that included the extreme measures of how libel and slander can affect a person's reputation. How did it get its name? A man named John Zenger was born in Germany in 1967. He immigrated into New York City at the age of 13 and spent 8 years as an apprentice under William Bradford, a pioneer printer. He later started his own printing business in the colonies. The next video will explain how the Zenger trial took place.
Before the Constitution established the First Amendment, English and colonial assemblies considered freedom of the press a danger to the state. But colonial newspapers vigorously defended their freedom. They insisted that citizens had a right to monitor and criticize their governments. In 1735, this right was tested by John Peter Zenger, a German-born printer.
John Peter Zenger was a newspaper editor in New York colony in the 1730s who published editorials lambasting the governor.
Sir William Cosby, the governor of New York at the time, was the object of Zenger's harsh editorials.
And the governor ordered him arrested for sedition and libel, and his paper closed. And in fact, some issues of his paper were publicly burned. Zenger was put on trial for sedition, that is, bringing the governor into disrepute. Zenger insulted the governor, no question about it. He called him a thief, a crook, a criminal. And yeah, that's against the law. It was definitely against the law. But he said, if you think he was right, truth should be a defense against that. His trial is important because his lawyer convinced the jury that Zenger was right, that the governor was a lowlife. And so the jury acquitted him.
The Zenger case proved that Americans valued a free press, an idea that would become law with the creation of the Constitution.
William Cosby arrived in New York on August 7, 1731 to assume his post as governor for New York Province. He quickly gained a reputation as a rogue governor and described as spiteful, jealous, quick-tempered, dull, unlettered, and haughty. No wonder that within a year of his arrival on American shores, Cosby embroiled himself in a controversy that would lead to the famous Zenger trial. To get more in depth about the trial itself, let's talk about how it started. On November 5, 1733, Zenger published his first issue of the New York Weekly Journal, the political organ of a group of residents who opposed the policies of the colonial governor William Cosby. Although most of the articles were contributed by his more educated colleagues, Zenger was still legally responsible for their content as publisher. The paper threw jabs at Cosby for a year until Cosby had him arrested for libel on November 7, 1734. Then, August the following year, Zenger was finally brought to trial. This animated video gives us a good visual on how the trial takes place.
Good. A fair trial. And the replacement lawyer was no slouch either.
Andrew Hamilton, one of the best attorneys of the day, came to New York to defend Zenger.
The trial began with the Attorney General Bradley reading the seditious libel charges against Zenger. Then Hamilton spoke, sending a shockwave through the courtroom with his opening statement.
I do, for my client, confess that he both printed and published the two newspapers set forth in the information.
Zenger admitted he was guilty.
Guilty of printing, that's all. But Bradley thought he had won.
As Mr. Hamilton has confessed the printing and publishing of these libels, I think the jury must find a verdict for the king. Not so, Mr. Attorney. There are two words to that bargain. I hope it is not our bare printing and publishing a paper that will make it a libel. You will have something more to do before you make my client a libeler. For the words themselves must be libelous, that is, false, scandalous, and seditious, or else we are not guilty.
Hamilton then proposed that if he could show the statements printed by Zenger were true, they should not be considered libel.
But Justice Delancey wouldn't allow him to prove the truth, right?
Right.
The law is clear that you cannot justify a libel. The jury may find that Zenger printed and published those papers and leave to the court to judge whether they are libelous.
Hamilton then revealed the true nature of the defense strategy. Jury nullification.
What's that?
Well, jury nullification occurs when a jury returns a verdict of not guilty despite its belief that the defendant is guilty. The jury, in effect, nullifies a law that it believes is either immoral or wrongly applied to the defendant.
Like in the 1800s when people were accused of harboring slaves in violation of the fugitive slave laws?
Yes, good example.
Well, let's see if it works here.
Your Honor, the jury may do so, but I do likewise know they may do otherwise. I know that they have the right beyond all dispute to determine both the law and the fact. And where they do not doubt the law, they ought to do so. It is natural, it is a privilege, it is a right which all free men claim, that they are entitled to complain when they are hurt. The question before the court and you, gentlemen of the jury, is not of small or private concern. It is not the cause of one poor printer. No, it may, in its consequence, affect every free man that lives under a British government on the main of America. It is the best cause. It is the cause of liberty.
Ooh, that's powerful.
Yes, and it worked. The jury returned only a short time later to announce their verdict.
Not guilty.
This case, New York Times versus Sullivan, is from 1964 and most recently represents a case almost identical to the Zenger trial on a nationwide scale. During the civil rights movement of the 1960s, the infamous New York Times published an ad for a fundraiser to help, support, and defend Martin Luther King Jr. A man named L.B. Sullivan felt that the degrading statements in the ad were reflected onto him. However, his name was never mentioned in the ad. New York Times refused the claims, and Sullivan filed a libel suit against them. To summarize, a published false statement in writing that can be damaging to a person's reputation is libel, and the action or crime of making a false spoken statement that can be damaging to a person's reputation is slander. Although these can limit freedom of speech and freedom of the press, they are for good intentions, which is why these cases are brought to trial to be fair to both sides. Of course, it is never okay to lie about someone to the public. But it also isn't okay for a public or political figure to try to oppress the people from knowing their right to the truth, especially if it can affect their livelihood. The Zenger trial showed how the government does not always have power over the press. Even today, John Zenger is still a big symbol for freedom of the press in the United States.